9 News legal analyst Scott Robinson joins us now to talk more about this process. And as we were just listening to that, you were telling us there are a lot of moving parts here. A grand jury indictment is far from a jury conviction.
Yes, it is. All the grand jury considers is probable cause, not proof beyond a reasonable doubt. But there are so many things going on at once. As the lawyer for the family said, the officer did make some decisions along the way, many of which violated either protocol or state law. I think perhaps the most telling was the decision to use deadly force without giving a clear verbal warning, because what the officer told investigators, ill-advisedly to be sure, is that he wanted to maintain an element of surprise. And that's contrary to the statute that requires a clear verbal warning with adequate time to respond. There also wasn't any clear articulation by the officer of an imminent threat to himself or anyone else. He was concerned about Belt Stubblefield getting the gun that he threw aside, or overpowering him and taking his gun. But in reality, this all started with the officer pulling his gun before he even had any interaction with Belt Stubblefield, which is troublesome. However, he is chasing an individual who was eluding police, had been involved in 2 accidents, did have a firearm, although the officer didn't know it at the time he pulled his weapon. And it's unfortunate, but Aurora police do not require carrying a taser. He had pepper spray, which he didn't feel like he could use because it would incapacitate both of them. And he had a retractable baton that he couldn't get to because he couldn't holster his gun. Also, he punched the suspect, Belt Stubblefield, in order to distract him from going to the gun. There's just so many missteps. But it's a complicated case. And as you note, Phil, it's a lot of moving parts that a jury will have trouble sorting out.
And that's it. The jury hears all sides, right? They
Yes.
hear everything about what led up to this, and then they're going to hear what the officer said, and then they have the video as well. But the grand jury, is that pretty quickly that they return this indictment?
Well, I don't actually know when they start because it's secret.
Yeah, that's secret. So
I mean, the shooting was almost a year ago.
Yeah, so
it's not like it's a rush to judgment. But, you know, this is the kind of case that's going to be very difficult for prosecutors to prove for a lot of reasons. On the other hand, it's really hard to justify what the officer did.
Well, then that brings me to this, and it's great to have your legal expertise, because I think, you know, even though our viewers have seen cases like this and we've covered cases like this, it's still confusing state to state. So they're charging 2 counts.
Yes.
One with murder, one manslaughter. So why do they do that? Is there a lesser included? Is that what it's called? Are they saying giving them a choice, or how do you charge both?
Well, you can actually do that right before the jury hears the closing arguments. But in this case, they've charged 2 alternatives. One is knowingly and unlawfully causing the death of Belt Stubblefield, and the other is recklessly. Recklessly, as defined in our statute, is a conscious disregard of a substantial and unjustified risk. That's not necessarily language that juries are used to dealing with. But it's very common for multiple offenses to be charged by a grand jury. As you point out, Kim, there's no pesky defense attorney cross-examining the witnesses at a grand jury proceeding. And yet, by and large, my opinion after decades of practice is that the vast majority of grand juries do their jobs honorably and according to the law.
And that knowingly and recklessly will factor in a big way. So we'll have a lot to ask you about with that, that's for sure.
I'm glad I'm not going to be a juror on the case.
Thank you so much,
Sure.
Scott Robinson, our legal analyst.